Hi, everyone. Welcome to Talk Back. It is October 9th, 2024. We're less than 4 weeks away, actually, as of yesterday, from our November 5th election. Although, I want to remind everyone that early voting starts in Connecticut on Monday, October 21st. Take advantage of all the early voting days and contact your town hall in your particular community to find out when you can do early voting. Registration's always open. Please vote. It's an important year. And we've been continuing our series of interviews with all of the political leaders and candidates for office. An important position is probate court judge. It's very important. It's something that people don't know as much about as they should. And so I'm very happy to be here today with a Democratic candidate for probate court judge in a district that includes some of the towns around here we'll get into. It's George Baker. Hi, George.
Hi, how you doing?
Good. It's good to have you here.
Thank you for having me.
Okay. So, George, you are an attorney because to be a probate court judge now, you must be an attorney.
Correct.
Okay.
Yeah.
And you have had a career for years now working in exactly the type of law that is essential to the probate court work, right?
That is correct.
Okay. So I always think in terms of, we call it trusts and estates, wills, conservatorship issues, guardianship issues, and we're going to talk about those and give a little bit of definition because some people out there are not familiar with a lot of these things. So as we age, we need to make plans for what might happen to us when we get sick, when we die, when we have property that we want to see who's going to get it, whether it's personal property or real estate, or whether it's bank accounts or retirement accounts, and so on, right?
Yep.
So what is the importance of making these type of provisions as you age?
Yeah. Well, we typically refer to it as estate planning. Most people know it as, oh, I have estate
An
planning.
estate means everything I have.
Right, all your assets.
Okay.
Kind of planning for the management and distribution of your assets.
And if you don't make a plan, then you're left with things going to the state or to people that you don't know about.
Yeah, it's very important to have an estate plan in place. When I'm really talking about estate plan, at least wills, your advance directives or health care for medical, and your financial durable power of attorney, because in the future, if something happened, incapacity, if someone's incapacitated and they don't have a financial power of attorney or they don't have their health care proxy, then they have to go to or family has to go to probate court and seek a conservator over them to manage their finances, to make medical decisions. So it's crucial for a client or individuals, everyone, to have these documents in place.
All right, let's start with the basics. So now I want to write a will. What is a will? Yeah. What is it?
Yeah, a will is a document that takes effect when you pass away. It's got to get submitted to probate court for approval and admission to probate. But it really governs, I call it your roadmap through probate. It's kind of your rule book to get through probate. It doesn't avoid probate, but it says who your executor is, who's going to do all of the work.
What's an executor?
Executor is the person the court would appoint to take control over the probate assets.
All right. So usually that would be my spouse or my children.
Typically. Yeah, it's typically the spouse or the children. Yes, who would be named by the individual. Sure.
So I have the power as an individual to decide who I want to get what assets, including down to the items of personal property that I have in my home.
Exactly.
Right?
Yeah. So the other thing the will does, it specifies who gets your stuff, right? Who are your beneficiaries?
Right.
So who gets the house? Who gets the cars? Who gets the bank account? Assets. And again, you could specify who gets, the grandfather clock, right? Or the kitchen table, my silverware. Now, we usually do those in a separate memorandum, but you can certainly specify.
Maybe a separate paper that's attached to your will.
Attached to the will that says,
something
okay,
like that.
for the personal belongings. But a lot of times the will may say something like, I call them I love you wills. All right, and I love you will says everything goes to my spouse if I die first. At the survivor's death, we leave it equally to our children, right?
Right.
We love our spouse, we love our children. I love you wills. Those are very typical wills.
How
Yeah.
many people in this country, you probably don't know,
Yeah.
don't have a will or have made any preparations for when they get older, when they get ill?
Yeah, I would probably think maybe anywhere from 65, 75% probably have a will. But that may vary by region too. You know, Colchester may have a higher percentage of people with wills than some, say, Wyndham does.
Right.
It could vary, but maybe, you know, certainly over 50%, maybe 60, 70% have wills.
So that's a document that you prepare to decide what's going to happen with your estate, the stuff you own
Right.
and stuff you have.
When you die.
Right.
Yep.
But then there's other important things and related to my health. So I'm getting
Right.
older. I want to have a piece of paper that tells the doctor and the people who are taking care of me what I want to happen. What is that called and how important is
Yeah.
that?
Our document's called an advance directive or a healthcare proxy. And usually what it does is it appoints an individual to be your healthcare agent to make decisions for you medically if you're incapacitated. So you're in the hospital, you can't make decisions. This individual that you appoint will make those decisions for you. Now, the document can be very broad and just leave it up to your agent, or you can be specific as to certain things you'd like no blood transfusions. Sometimes clients would want to. So you could put specific conditions in there as to exactly what you would want for health care. I have had clients who said no amputations of limbs. You know, very specific things that they would want relative to their health. All right. So that's one component of that. The other section of this document is what we call a living will. A living will specifies if you're terminal, permanent vegetative state, no hope of recovery, that it's your desire to not be left on life support. Again, that's your direction to your agent and to your doctors as to what your wishes are. So it's ultimately the agent's decision as to consulting with the doctors and all of that
So
to make
that's
those.
another important document you should have.
Yeah.
And then there are documents called powers of attorney.
Right.
I'm going to give somebody the right to help me make decisions or stand in me instead of me for different things. What is that?
Yeah, the durable power of attorney handles where you're designating a person, again, an agent, to handle your legal and financial affairs. Go to the bank for you, you know, manage your assets, make withdrawals, you know, do your investing for you, pay your bills. Somebody that has legal authority to handle all of your legal and financial affairs. Yeah.
And that's important as you get older.
Sure, because without these documents, the advance directive for healthcare and the durable power of attorney, if somebody's incapacitated, they don't have those documents, we've got to go to probate court to seek a conservator.
All right, so I'm in the hospital. I
Yeah.
don't have the power of attorney and I don't have the living will. What happens?
Yeah, well, no, your spouse doesn't even have authority to make decisions.
Really?
Correct. You know, now, if it's a joint bank account at the bank, right, your spouse can go in because they're a joint owner. But let's say you have your bank account in your name alone, and you know, no one has authority to access that account unless you have a power of attorney, or someone gets appointed as a conservator, and it's called a conservator or conservator of the person and a conservator of the estate.
So there's an impasse at the hospital as to what medical treatments to do. We have to go to probate court to
yes.
assign a conservator of the person?
Yes. Mm-hmm.
Okay.
And there's a whole process that gets initiated when somebody files a petition. Normally it's a family member who's concerned about mom or dad or something, and they're not able to care for themselves and make proper decisions in their view. So they file a petition with the probate court, and then there's this whole process initiated by the court, namely appointing an attorney for the person, having a hearing. We have to have doctor testimony about somebody's capacity.
Okay. Well, let me just take the situation where we're in the hospital and we have an important decision to be made. will the probate court be able to work fast enough
Yeah,
to
there's
take care of this?
Yeah, there's expedited process when we have an emergency situation. So maybe within 24, 48 hours or so, pretty quickly, we can get
Get someone appointed.
get someone appointed,
Okay.
and
But if a family member, like a child, wants to bring a conservatorship action because they feel like the parent is not capable of handling his or her own affairs, especially medical affairs, then you have to start a whole process to investigate that, have a hearing, right?
That is correct. There's a hearing. Again, your court-appointed attorney for you would come and meet with you and make a determination.
Now I have a court-appointed attorney because maybe I don't want my children to get a
You're
conservator
right.
for me. And I might say, I'm capable of handling my own affairs. I don't need the help. I don't want to have a conservator for me.
That
Is
happens.
right?
That happens where the person believes that they're, that they can take care of
Right.
themselves.
So
They don't need them.
So the court requires that there be a lawyer appointed for me to take my interests at heart and to represent me in this hearing.
Correct, for due process
Right.
rights.
And I even have to do it even if I maybe agree that my children should, because that's
Well, no,
part
you
of the
could
process.
do it. You could actually do a There's two
You
types.
can do a
You can
voluntary,
do a
okay.
voluntary. So if you're capable, you could actually say, you know what, I just don't want to handle my affairs anymore. I'm going to file a petition for a voluntary. In that situation, the judge has to find that you are capable
Right.
to do a voluntary.
Okay.
There's no lawyer appointed for you in that type of case
Okay.
because you're capable.
Right. But when
It's
a
the,
law, right, I
it's
got
the
it.
involuntary where you're incapacitated, or the argument is you're incapacitated. Now there's a hearing, and the judge.
And in a hearing, the lawyer appointed for me might get a doctor to say that I'm not incapacitated.
Correct. They could have an independent, evaluation that says, "Hey, she's completely fine."
Or
capable.
another doctor could come in and say she's not.
Correct.
So
You could have a battle of the doctors.
Okay.
Yep.
So in that hearing, as a judge of probate, do you have to follow all the same rules of evidence that you do in any other court of law
Yes.
in Connecticut?
Yeah.
So probate court is a separate court.
It is a
though,
separate court, a little less informal,
right?
right? But yet, if we're having a contested hearing, we follow the same rules of
Okay.
evidence. Yeah.
Sometimes they talk about will contests where
Yeah.
somebody has
Yeah.
a will and they find a second will and somebody says that's the will under which
Yeah.
I want this estate to go forward. And same thing, you might have a hearing in the probate court with,
Oh, yes.
with evidence
Yeah.
and
If it's a will contest where
they-
an
okay.
argument, did somebody,
Okay.
There's certain standards you have to apply, right, for the determination of, there's a presumption of validity of a will.
Right.
But yeah, you could have a contested hearing where someone could come in and argue. There are very limited grounds for a will contest. It could be like undue influence, someone forced you to sign a will at your,
Right.
lack of capacity, mistake of fact. There's, again, those criteria.
aren't there sometimes conflicting wills though? You said
Yeah.
one
Yeah.
gets written later than another.
Yeah,
and
a lot of times the ones that are susceptible to will contests are those deathbed wills, right?
Right.
Somebody brings mom to the, or has the lawyer come in on their deathbed and they sign a new will
Right,
and
right.
leaves everything
Right.
to one person. Yeah, those
Right.
are the wills that are going to be challenged.
Okay.
But the vast majority of cases, it's
Right.
standard.
So at the very
admission.
least, everyone who has any estate at all, a house, a bank account, a retirement account, should have a will where they designate a beneficiary for those things, right?
Correct. Yeah.
And at the very least, everyone should have a health proxy or a living will where they designate who is going to help make decisions when they become ill or incapacitated, right?
Exactly.
Much better to have that than to have your family go to court
Right.
to be appointed a conservative for you, right?
Right. I'm a big advocate of even though I've served as a probate judge and I want to serve again as a probate judge, my philosophy is avoid it if you can
Right.
by getting the proper documents in
Right.
place.
So the will, the living will, and the health proxy, a durable power of attorney, so that you can have someone stand in your
Sure.
stead to do legal things or money things and
Yep.
take your place in different situations
Yep,
that
exactly.
you've agreed to.
Yep.
And if you don't have those things, what happens?
Yeah. Well, again, if I'm incapacitated, we've got the conservatorship process. But then what happens is once the judge makes a finding of incapacity and appoints someone, now the court kind of oversees whether it's financial or medical. So there'd be accountings, there's periodic reviews. The court is overseeing whether the person appointed is acting properly.
Right.
So there's this whole process involved in the probate court. When someone dies, if they don't have a will, the government tells us how the assets are going to get
And
distributed.
does that have to still go through the probate
It's
court?
still.
How does that work?
Yeah. So first of all, there's certain assets that would go through probate. When we say go through probate, those are assets that a person owns individually, has no beneficiary. So certain assets do not go through the probate
So
process.
I own a house in my own
Yep.
name. I have a bunch of bank accounts in my own name. I have a bunch of personal property,
And you got a
jewelry
car.
in my own name, a car,
Typically,
right?
car, personal belongings.
And I have never written a will, so
Yep.
no one knows who's getting those items.
Right.
So who gets them? How
So
does
you
that
passed away, no will. We've got to appoint an administrator who would take charge of your estate, and the state statute would say who gets. So if they're married, it may go to the spouse. But if you have children, it may not all go to the spouse. Most people don't realize that. So if the decedent, the person who passed away, has children, and all of the children are also children of the spouse, then the surviving spouse gets the first $100,000 of the probate assets plus half of the assets above that $100,000. All right.
So if it's a significant estate, the children can get a lot.
Oh, sure. If I had $1 million estate going through probate,
Right.
the spouse gets first
Right.
$100,000.
But ordinarily, if you thought about it and made plans, you would probably want the spouse to get everything
Yep.
and then leave what the spouse has left
Exactly.
to the children when the spouse
Sure.
dies.
And if the decedent had children, but not all of the children are children of the surviving spouse, the spouse doesn't get the first $100,000. From every dollar goes split 50-50.
Okay.
So then the children are going to get more.
People may not be aware of that. They may think automatically, well, if I don't have a will, it will go to my
right.
husband.
You go to my.
But that's
right.
not right.
Right. Now,
mean,
without a will, though, certain assets can obviously still go directly to people outside of
Okay,
probate.
so I have a bank account. I put my daughter's name on it
Yeah.
and survivorship. That's going to go to her when I die. It doesn't have to go through
Probate. Yeah.
I have a house in survivorship with my husband. Doesn't have to go.
Correct.
I have a 401k, and I've already named beneficiaries of that.
Right.
That's all. Retirement accounts, right?
Right.
Most people have assets like that
Yeah.
that automatically will go to the survivor, right?
Yeah, exactly. So I could have a client who comes in and says, George, I don't know if I really need a will because we own the house jointly, the car's joint, the bank accounts are joint, my 401k has my spouse and children as beneficiaries. Why do I need a will?
Yeah, and what do you tell
My
them?
answer to that is we don't know at your death whether there's going to be something to probate or not. All right? You could be in a car accident, pass away, and you have a lawsuit against the responsible driver for a wrongful death claim. You don't have a will. All right? That would be a problem. All right? So
How would that be a problem?
well, because again, you'd have to then admit, you don't have a will to probate. All right, if your estate, had a $500,000, $1 million settlement, that's a probate asset. If without a will, it may not all go to your spouse again. All right, and maybe the first half or 100,000
Same
goes
thing,
to you.
right.
That same rule about intestacy without a will would apply.
Right.
So I say to people, it's still important to have that will
Have that
because I
will.
don't know in the future whether you're going to have probate assets or not.
Right.
So
And then some people have a simple will, as you
Yeah.
said. I think you called it "I love you" will.
I love
where
you, yep.
Everything goes to your spouse or
Spouse.
your children and
Right.
so forth.
yeah.
And then there are trusts. What is a
Yeah.
trust, and why do some people
Okay.
need that?
Right. A trust is a separate document. Typically, what we traditionally know is what's a revocable trust. All
That
right?
means you can undo
Change it. You can
Okay.
modify it. You're the trustee while you're alive.
So what does that mean? I'm collecting certain assets in this trust, and what's going to happen
Yeah.
to them?
So what'll happen is people say to me, "Well, George, I want to avoid probate. How do I avoid probate?" Well, as much as possible, you could avoid probate by setting up a revocable living trust where you're the trustee. You put certain assets. I transfer my home into it. I transfer my brokerage account. I may transfer bank accounts.
Why would you do that if you've already put a survivor beneficiary on those assets?
There are reasons you may want it to go through a trust versus going directly to a beneficiary. Minor children, right? Maybe I have a concern about my children's ability to manage assets. Maybe I have a child who's special, special needs. There's all these reasons you may say, well, geez, I don't want it to go directly to my children. I want to set up a trust for them.
Got it.
Maybe you're setting up for your grandchildren who are minors.
Right.
So you want to be able to have those assets
Important
managed.
thing is you need to go to lawyers like you
Right.
and tell them what you have
Right.
and what you want to do with it.
Sure.
And the lawyer will help you find the maze to go through to set up the
Exactly.
proper documents for you.
Exactly.
Right.
You
So in the probate court, you die, and then there's a will. What happens?
Yeah.
Who goes to the probate court?
Yeah, so procedurally what would happen is someone passes away, let's assume they have a will. It's usually a family member, it could be a spouse, it could be the children. They got to find the will, right? They've got to admit the will. There's certain documents you got to submit, the death certificate, the will. You got to give notice to the heirs at law for a hearing, because the will isn't automatically admitted. We have to go through a process to admit it. The court does that, but you got to give notice to those people who are heirs, and heirs are the people who would inherit if there was no will.
So they even have rights even if they're not named in the will.
Yes. Yeah, I could disinherit a child. That child has to get notice of the admission of the will.
Could that child make a claim
Yep,
against the
they
estate?
can contest it.
Why can they do that?
Well, they have a right, because if they could knock out the will, if they could prove they can knock out the validity of the will for whatever reason, they would inherit, based on the state law.
I see.
So I couldn't just go and contest your will, right? I don't have standing to contest your will, right? But your child would have standing even if you disinherited them. So that's not uncommon that someone gets disinherited, they get a copy of the will, find out mom left them out. They can go to probate court. They're going to get a notice from the probate court saying there's going to...
So everyone that might have an interest in that person's estate gets notification.
Correct, yes.
And then usually in the will you name an executor or an executrix, a man or a woman.
Yeah.
What is the job of the executor?
Yeah, it's really to garner all of the probate assets.
So we have to collect them.
Collect all the assets.
Then we have to value them.
And
put a
value them
on
on the inventory, on the estate tax return. They all get valued. I may have to collect the assets. I may have to dispose of the assets. I may sell the assets.
Well, you dispose of the assets the way
the will says.
The way the will says.
Of course. Yep. Mm-hmm.
Okay.
Yeah. But there's a lot of flexibility and leeway for the executor. So it may say, my personal belongings shall, can be sold or distributed, at the discretion of the executor. So there is some discretion.
So the executor can take all the jewelry and give it to the various people in the family, whatever.
Yeah.
Depending on, or it could be very specific.
It could be very specific.
This ring goes to this kid and this and that type of thing.
Yeah.
So there's a lot of discretion that you have to say what you want.
Sure, exactly.
And that's important for people to know.
Exactly. I could say, well, I want this property to go to a certain person. I want this asset. I want this car to go to a certain person. Yeah, you can be very specific. Or, again, those I love you wills, which are everything to the spouse, and at the survivor's death, everything goes equally to the children. That's all it says. It's not specific as to particular assets.
Okay. So we're just touching the surface. As an attorney and someone who was a probate court judge, we'll talk about that in another district years ago, you have gone out into the community and done a lot of education, which I think is important. So where have you gone? What do you do to educate people to what they need to do?
Yeah, I think that's very important, that people just don't understand the significance of having these documents in place. So I traditionally have given my own workshops and presentations, advertise those, and just speak. I love to speak. I'm a teacher at Manchester Community College, so I love to educate and teach. But I go to senior centers. I go to different groups and organizations in towns and speak. So I may go speak to financial advisors, educate them as to the importance of getting their clients in. It's a good way of educating people is through other professionals, accountants, financial advisors, other people who are meeting with clients and explaining to them the significance of getting a plan in place. Or I speak at the senior centers. I do that quite a bit in Colchester. I do it in other surrounding towns, but I've developed a good relationship with those senior groups. I just spoke a few weeks ago at Northwoods in Colchester,
yeah.
the 55 plus community. So I spoke to the single group there one evening. And it's just getting out there and educating. And I plan to do that. I did that when I was a probate judge earlier, speaking with various groups,
Right.
organizations. There's no fee or charge, or I'm not looking
And you'll
for.
continue to do that if you're elected.
Oh, without a
judge.
doubt, I'll do more of that in
Very
the
important.
in the
Very
district.
good.
Yeah.
So now let's get back to the structure of the whole probate court. So years ago, each town had their own probate court judge, and you
Right.
didn't have to be a lawyer.
Mm-hmm.
But now, some years ago, they changed that, and they not only made it necessary that a lawyer be a probate court judge, but they consolidated districts and put together various towns into it. So now you have a district that you're running for. What district is that?
Yeah. Well, first of all, the probate judge has to reside in the district that they would serve in. All right. So if I live in Colchester, so the district, the 28th probate district is Colchester, Lebanon, Wyndham, Chaplin, Scotland, and Hampton. So there's 6 towns in that district. So the judge has to be from that district.
Has to be with the town. Before, you were a probate court judge in the 90s?
Yeah, late 90s, yeah. I was a probate judge in the Willington-Towin probate district.
You were an attorney by then?
I was 27, 28 years old. I was the youngest probate judge in Connecticut at the time.
And you ran, I think you once told me you ran because you thought the administration of the probate court judge wasn't doing that well in that town
Correct.
at that
Yeah.
time?
Yeah, I was a younger attorney doing probate work in my firm, and that court had some issues, deficiencies. There was some issues with the probate judge. He actually was not a lawyer, but I primaried him as a Democrat. It was a Democratic primary. I beat him in the primary there. And then he did a write-in candidacy against me because there was no Republican on the ballot. But I beat him in that. So I served as a probate judge. I came in and I completely overhauled. I got new staff. I got trained and educated them on the proper procedure. We completely turned the operation of that court around. I actually got accolades from probate court administration and how well we turned that probate court around. And I turned it over to Judge Cheryl Brown, who was my clerk at the time, because we ended up moving out of the probate district.
And that's when you still didn't have to be a lawyer, even
You
though
did
you
not
were
have
a
to be a
lawyer
lawyer,
at the
correct.
time.
But I was
Right.
a lawyer.
And
Yeah.
then you told me you moved out because your kids' education was important to you and you didn't want to stay in that district.
Right. We decided we wanted to move out of Willington for education. My oldest daughter was starting kindergarten, and so we moved to Ellington. My wife at the time was a school teacher in Tolland. So we could have moved to Tolland, but she didn't want to live in the town that she was a teacher in, which I could understand.
Yeah.
So, but I did. It was one of those things that I wish I had continued on because I love the position of probate judge and helping people through very difficult times. And it was one of those things that I wish I could have stayed in. But I did it what I thought was best for my daughters. They have great careers. They had a great education in Ellington. We're very happy with that. But at the same time, I miss being a probate judge.
Okay, and then
Yeah.
what was it? So now you live in Colchester.
Yeah.
What was the cause of that move? How did that happen?
Well, that's a long story, but the bottom line is I recently married my wife, Michelle, who lived in New Hampshire. All right, and so we were contemplating whether I'd be moving to New Hampshire or we should be coming here to Connecticut. And I ended up selling my house. We were looking at potentially me moving to New Hampshire, but ultimately the decision was made. She sold her house in New Hampshire, and I said to her, Michelle, you get to pick where we live, all right? And I knew Connecticut. I grew up here. I lived here. I know certain towns that I would want to be, because I have to go to Glastonbury. She has to. So we wanted to be near Route 2 or 84. So she fell in love with Colchester, and that's where we ended up
Okay.
moving to.
And so now, as part of the Colchester district, you decided to run for
Yeah.
probate court judge. And so we have a probate court judge now,
Yes.
but because of the retirement rules, that probate court judge is in the middle of his 4-year term,
Yes.
which wouldn't normally end till 2026, right?
Correct. Yeah.
But he's going to be 70 years old in June.
Yeah, Connecticut Constitution says when a judge in Connecticut turns 70, they have to leave office.
So that day he turns
That
70,
day.
he can no longer be a probate. But the state has decided to have a special election in this November
Right.
so that a probate court judge can be appointed, elected, but you're not going to take office until June 13th.
June 12th of 2025.
June 12th of
Yep, June 12th of 2025.
yeah.
So you get elected November 5th. Judge McGrath is still there for the duration of until he
Right,
turns 70. And then I would serve like a year and a half, and then we'll have another election.
Then you have to be elected for the 4-year
Four-year
term.
term.
Okay.
So this is to fill out the balance of this
Of the
current
term,
4-year
right,
term.
got it.
Yeah.
And in order to run, it was very interesting, you had to win a Democratic primary in August when in the heat of the summer, nobody knew there was a...
Right.
There were several primaries in towns around the
Sure
state,
there were.
different
A
things.
few.
A few. But you worked and traveled around
door
the
to
district,
door. I
went
went
door
door
to
to
door,
door.
and you managed to eke out a win,
Right.
beat your Democratic opponent.
Yeah, it was unfortunate because you would think, I think, maybe I'm naive, that qualifications may matter, right? Especially for probate judge, but it's interesting how the politics plays. And probate is not political.
It
It should
shouldn't be.
not be. And
I
the whole
know.
process of electing probate judges, I think, is archaic, but that's a whole nother debate. But, you know, Wyndham wanted a Wyndham person. I don't
Right.
have any intention whatsoever to move the court out of Wyndham. I'd like to establish hours in Colchester, in that area of the district, to make it more accessible for the
Right.
people. But I have no intention of removing the court from Wyndham or anything like that. To me, I don't think it should matter whether someone's from Wyndham or Colchester or Scotland,
As long as they're in the district.
as long as they're in the district and they've got the capabilities.
But that's politics. As you
It is
said,
politics.
attorneys running for probate court judge shouldn't have the same political sensibilities as other offices, but
I agree.
that's politics.
It is politics, the
It's
process of getting them elected. But so, because Wyndham had more delegates at the convention, because you got to go through the convention, he got the delegates, more
So
delegates.
you had to primary.
And I had the primary.
And you
I
won.
went out there and won.
Okay.
And
now you're running against a Republican
correct.
candidate,
Yeah,
and you hope to win
Sure.
in November.
I do. I plan on it.
You plan on winning
Yeah.
in November.
Yeah.
And then, as you said, although the main basis of the court is in Willimantic, right?
Yep.
You will have office hours in Colchester. What do you envision? I also read somewhere, we'll see it in your PowerPoint, you have to work at least 20 hours? Is
Yeah,
that
there's a
rule?
minimum standard requirement for the judges once they get elected that they have to serve them. They have to be in the court at least 20 hours a week.
Oh,
All right. Now, a lot of judges continue their law practice. Judge McGrath is practicing attorney.
right.
So they spend part of their time in their private practice and then in the court. I'm planning on phasing out my law practice because I want to commit 100% to the position of probate judge.
Right.
You know, inevitably you could have conflict interests and things, conflicts of interest and all
Right.
of that. But
Right.
I also want to do it because I love the position. I want to focus on that. I want to improve the operation and efficiency of
Okay.
the court.
What you don't, how busy you're going to be is really a function of how many. You really don't have any way of knowing in that particular year how many cases you're going to have.
You're right.
How does that work?
You're
Is
right.
there an average amount
Well,
of time?
the probate administration has statistics
Yeah.
as to how many, how many cases come in. I mean, there's different types of cases. Probate doesn't just handle estates.
I know we were
right.
getting into
Yeah.
that. Yeah, I was.
So, it could be children matters, or it could
Let's
be.
talk
right.
about that very briefly.
Yeah.
Guardianship. So, I always thought that the Superior Court handles custody, maybe in relationship to parents in divorce cases. But what does the probate court do when it comes to guardianship? I'm a grandparent,
Yep.
and I need to
Yep.
take charge of my grandchild for one reason or another. Do I go to the probate
Oh,
court for that?
Well, there's certain matters that have concurrent or
Which
dual
means-
jurisdiction.
So go to one court or the other.
Right. So some of those matters you can bring estate administration, strictly probate.
Right.
You can't go to Superior Court to probate a will.
Right,
All right.
right.
But a guardianship matter or a child matter, they could have like a removal or a termination. you could strategically decide whether you want to bring it in probate court or whether you want to go to
What would
superior.
enter into your thinking about what the strategy would be for that?
Well, see, being a person that deals with probate courts all the time, I just like the environment of the probate court versus a superior.
More informal.
It's small, it's less formal, it can be more expedient, much more expedient. So those are reasons I may want to bring it in probate court versus superior court. Interestingly enough, though, whenever there's a matter decided by probate judges, a aggrieved party, someone who didn't like the outcome, could always
appeal it
to superior court.
So you get another hearing.
You get another crack at the apple, right?
It's not like a regular appeal where you can't redo it. You could redo it that way.
Right. So some people like to use the probate court as this, the initial process of getting all the evidence.
So besides estates, and we talked about all that, and now guardianship issues involving children.
Yeah.
I mean, what's the usual situation that comes up? I said grandparents is a big part of that.
Well, there's many different ways. I mean, I could have a child who's in an accident and they get a lawsuit, a settlement.
Okay.
But they're at 5 years, a 10-year-old child. We're not going to give a 10-year-old child $100,000 in a settlement, right?
There you go.
We need a guardian over their estate.
Right.
So we have guardianships over persons. We have a parents who die in an accident, God forbid, right? And you got a grandparent who comes in and now wants to be guardian for their minor grandchildren.
Right.
That's in probate court. Yeah, you would bring a guardianship proceeding. May have DCF involved as to what's appropriate environment for the children and all of that. There's involvement. Now, probate courts a few years ago they established these children courts. All right, so there's 6 children courts throughout Connecticut. One of them is in Wyndham. All right, in Willimantic. Actually, they just built a new court there, right?
Right.
So there's and that just handles a lot of the more delicate children matters, termination, removals, a lot of those contested matters, where they've got more resources dedicated to children's issues. That's not in the 28th probate district. So a lot of those children matters have gone to the child court now. But you still have the general ones would still be in the regular probate.
Is there anything else the probate court does?
Yeah, conservatorships, obviously.
Yeah, we talked about
there
that.
could be, if there's, let's say, an adult person who has intellectual disabilities, they may need a guardian for them. Trust administration. If there's a testamentary trust, that's a trust in the will. That's governed by the probate court, overseen. There's accountings, there's hearings. If with a revocable trust I told you about earlier, normally that's not in the probate court, but if there's a dispute between the parties, someone can petition to have the court become involved. So there's trust administration, estate administration, conservatorships, adoptions.
Adoptions.
Adoptions are the one fun thing you can do as a
right.
probate. Most of these topics are depressing, right? Dealing with
adoptions
death and dying and conservatorships, those aren't really upbeat matters, but an adoption is.
Yes. Okay.
Probate judges also can perform marriages.
Right.
So that's another fun thing a probate judge can do.
Right.
Perform. I did about 6 of them when I was a probate judge previously. Love to do a marriage.
Well, I'm a justice of the peace too, and I.
Oh, do you? Yeah, it's fun.
It's a lot of fun. Yes.
So those are the various topics
Okay.
that are handled, or subject matters that are handled by the probate court. But you're right. I wouldn't know how many cases come into my court in a year. It's based on what happens.
What
right?
happens, right? Okay, let's turn. We have a PowerPoint that kind of goes over some of the things we've already talked about. Can we look at the PowerPoint and see what we have? Look on the screen. Okay.
So a
talk
summary
about
here.
that.
Yeah. So there are 54 probate court districts in Connecticut. Again, that was kind of established when they merged the courts, and they kind of just, decided how they would put the courts together. Again, there are those 6 regional children's probate courts. Judges are elected to 4-year terms. It's normally coincides with the governor's election, right?
Yeah.
So that'll be 2026 again. You do have to be a licensed attorney, and the requirement of, again, we spoke about earlier, that the judge has to be present in the court 20 hours a week. But again, they can still continue to practice. A lot of judges continue to practice.
Okay.
You know, but there are limits or restrictions on my ability. I couldn't handle a probate matter in another court,
Right.
or certainly couldn't handle a probate matter in my court. And so there's restrictions about my ability to, you know, but if I was a real estate lawyer, there's no restrictions, right? Or
Right.
I was a criminal lawyer.
Right.
I could do all of that. So.
Got it.
Yeah.
Okay. Next, let's go to the next slide. We
Yeah.
talked about
So
that.
again, we talked a lot about this. There's the decedent's estates and trust. That's under the probate court jurisdiction. Children matters, again, terminating parental rights, removal of adoptions, custody, again, guardianships of the person. So again, parents pass away, or not there for whatever reason, they walk away from a child or so. You can designate, you know, a guardian. Could be the grandparents or somebody who would, you know, the child would go live with them. So they would make decisions regarding the raising
Right.
of that child. Guardian of the estate is financial again. The child gets a settlement or inherits. We get this, you know, parent passes away and the child is now inheriting and they're a minor. We're going to have
So
we need a
yeah.
guardian to manage those assets. Called a
right.
guard. A paternity claim could be brought in probate court. You know, whether it, someone, you know, individual is the, you know, biological
Right. Right.
parent of that child. And for adults, we would have incapacity issues for a conservatorship. For remember, an elderly person that, you know, conservatorship, but also a commitment. There are commitment proceedings. Those are handled in probate. So we have a person who's unstable, maybe a risk to
Can be
themselves.
committed to a hospital,
Hospital,
or mental
right,
hospital
for
facility.
72 hours. There's all
Right.
these guardianship for, you know, an adult now. So I have a child who has some intellectual disabilities. You know, when they're a minor, I can, as a parent, I have control. But once they turn 18, they can make their own decisions. So we'd have to get a guardianship for that individual. So, and that
Okay.
could continue for their entire lifetime.
Okay. Next,
Yeah.
what do we have? Oh, we already have that. Next slide.
Yeah. Oh yeah. So here's why the special election here in the district. You know, because when the judge turns age 70, they have to retire. They have to leave office on their 70th birthday. So if the governor didn't call the special election, what would happen is this court would have no judge for a year and a half.
Right.
So what the governor is trying to do is prevent another special election on its own, right?
So make it for the regular election.
Yeah, just
time.
tie it into
Yeah,
the
tie it.
regular.
And
That's
I
why
you say
yeah.
6 districts already need this special election.
Right, there are 6 of them
28
this year.
towns will be affected of that.
Right.
Yeah.
So the governor, for 6 districts in Connecticut this year, there's special election for probate judge, and it involves
Right.
28 towns.
Got it.
Yeah.
Okay. Next one.
Yep.
Next slide.
And again, John McGrath retires in June of 2025. It's again on the November 5th ballot. You get elected.
Right.
Once I get elected on November 5th, I begin serving in June of 2025. Again, it's Chaplin, Colchester, Hampton, Lebanon, Scotland, and Wyndham.
Okay.
And then again, and you know, 2 years from now, we'll be back in an election again.
Right.
Yeah.
Okay. And the
Yeah.
next slide. I think this is the last. This is all about you.
Yeah. I again am the Democratic candidate because of the primary victory a few weeks ago. Again, I did serve as the town probate judge from 95 to 99 until for that one term. I do have over 30 years of experience as a probate attorney, estate planning attorney. So I do estate planning, wills, trusts, all of that, elder law planning, all of that. So I certainly have a lot of experience there. And I'm an adjunct professor at Manchester Community College. I teach the probate and estate class there. I've done it for 8 years, and I love it in the paralegal program.
Great.
So they love me there. So
Okay.
I love to do it. And I live in Colchester with my wife, Michelle, and our dog, Chester. We just got a puppy, we just got a golden
Okay.
doodle. He's a 6-month-old golden doodle.
Okay.
He's adorable. So, and I have 2 children from my prior marriage who are adults, and my wife, Michelle, has 2 adult daughters as well. So we've got 4 girls, but they're all out of the home now.
Okay,
but
great.
yeah. So,
All right, great. So I think we've covered the territory for the
Okay.
most part. And why don't you tell us how people can get in touch with you? Do you have a website or?
Well, I do have it's more of a Facebook page, no
Okay.
specific website.
So George Baker.
Yeah. Well, they could get they could get me at George Baker, or my email, which would
What's your email?
G Baker, so GBAKER 64 at yahoo.com.
Okay.
That's my personal.
gbaker64@yahoo.com.
Correct.
And anybody can email you
Email
or chat
me,
with you.
yeah.
And you'll be traveling through the district.
I do. I've been going to door. I did door to door in the primary. I'm continuing to do door to door.
And you're getting reactions. People kind of know what you do, what it's all about.
For the most, I mean, people will, understand a little bit of what probate's about. One of the biggest challenges I had in the primary was to educate people about the primary. They didn't know about this.
Right.
So just getting people educated about it, and it's on the ballot. Most people still, when I go to doors, they're like, I didn't know this.
Yeah.
I didn't know this. I don't know this.
Well,
Most people will say to me, wow, you're highly qualified.
Right.
I think I am.
Okay.
So I get a lot of positive. It's funny because I go door to door, and I don't think it's the traditional politician going door to door. Because when you knock on the door and okay, here's a politician, right? And it's like, well, I'm running for probate. Oh, okay. It's not. It takes away that.
Yeah.
That tension, and people. It's
Right.
nonpartisan.
And I hope by having you on today, we've explored how important it is that people take account of these issues and make these preparations. Even though we all have to one day or another be involved with the probate court, there are so many things you can do on your own to take care of your future after you've gone.
Without a doubt.
And it's very important.
Right, yeah. It's
And,
very important to get some planning in place.
Right. And so we really appreciate you coming on. Good luck in the election.
Well, thank you.
And we're going to say goodbye for Talk Back Now. And we want everyone to, of course, vote on November 5th. But just as important, try to get out to the polls between October 21st and November 5th, when we have many days, 2 weekdays of early voting. Okay? Yeah. Bye, everyone. Don't forget to vote and educate yourself about the issues. Bye.